Hello and welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal, and we do estate planning here in California. And I'm going to answer a question I got almost every time I've done a seminar. We do a lot of educational events for our firm. And one of the things I get is, can I just have my kids put their stuff in my trust, or can I put my stuff in their trust? Like, I don't want to worry about it. I don't have to create a trust. And then they inherit my stuff and they have to have their own trust. It seems like a lot of work. I'm like, yep, I hear you. That would be really cool, wouldn't it? And the answer is no, don't do that. It's a terrible idea. Absolutely terrible idea. Why? Let me go over the reasons. The first is if you put something into someone else's name, you are giving up control of that asset and you are also gifting it to them. You are giving it away. Ali Goff says, you know what? I'm going to put this house in my kids' names. By the way, this has happened before. Cute little, you know, Benry and Walliver, they get my stuff. And then I'm like, oh gosh, interest rates have gone down. I think I'm going to refinance now. We go to the company to refinance it, and they go, well, we need Benry and Walliver to, those aren't my real kid names, by the way. I just thought they were funny. We need Benry and Walliver to sign off. They're minors. You now have to go to court and get a guardianship over your own kids so that you can sign documents on your behalf for a house that you purchased, all the while paying a lot of money to attorneys to clean up this absolute mess. You also have to file a gift tax return because you have gifted money to someone else above the annual exclusion limit. You're only allowed to gift a certain amount of money per person per year. So that's reason number two, gift tax concerns, making sure that you're keeping track of gifts and it's eating into your lifetime exemption. So we talked about control, we talked about taxes. Let's talk about capital gains. Even more important. Here's the scenario. You decide you don't want to create a trust. I don't want to spend the money. I just want my kid to have the asset. You bought the house for $100,000 in 1930. It's been a long time. Maybe not 1930 now. 1950. You bought the house in 1950. It's now 2025. You're going to give the house to the kid. Okay, great. You gave it to them. We filed a gift tax return. You weren't worried about that part. You weren't worried about control. Not a big deal. Fine. You didn't want control. You didn't want the house anyways. Let's say the house is worth $1 million today. The day after they inherit it, you give it to them, they decide to sell it. They don't want it. It's not in the mood, whatever. Or they sell it anytime in the future. They have to pay capital gains on the gains of that property, not the gains from when they were gifted it, the gains from when you bought it. So if you bought it for $100,000 and they sold it for $1 million, they have to pay capital gains tax to the federal government on $900,000. That's going to be a hefty tax bill at 30%. Now, if you had that house and gave it to them after you died, either by will and probate, if you have to, or trust, which is better, their basis resets to when you die, which means if you died and it was worth $1 million and they inherited it then, and then they went to sell it for $1 million, their capital gains exposure is $0. You can see how making a decision about like this could be really, I think I want to make this easier for them. You might have made it easier, but you have financially caused them a lot of harm and they will not be pleased. Why? Because it's not the money is going to, it's going to go to some of the lawyers. It's going to go to the federal government, which could have been avoided if you had your own estate plan. You kept your stuff in your name until you died, and then you gifted it to where it needed to go. Now, of course, there are some gifting strategies that we employ if you have over the amount, the lifetime exemption amount, and we need to get stuff out of your estate. Fine, different conversation. We're going to watch a different set of videos. That's not today's video. But making sure that you're not just sticking your stuff in their trust or their stuff in your trust, you're causing a lot of ownership, income tax issues, capital gains, and gift tax messes. It's not set up for that. It's not set up for that. The other thing about it is making sure that you have your plan set means we're not just worried about death, we're worried about incapacity. We're also worried about your healthcare decisions. Your plan should include your trust, your will, your power of attorney for finance, and your power of attorney for healthcare. All of those things are a comprehensive plan. Without one of them, there's a hole that could necessitate emergency action and a boatload of attorney fees coming your way because you didn't have the document that you needed. So that's the reason why we do not just stick our stuff in our kids' names or our kids' trusts or our kids stick theirs in ours. Not recommended. Please don't do it. If you'd like to plan your estate properly, you can contact us at gofflegal.com and we're happy to walk you through what that looks like and get you set up absolutely lovely. All right. Thanks for watching.